You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
We're back, members of the jury, and happy Freedom Friday. Today we have an amazing trial breakdown and even an insight into the process after trial when things don't go accordingly. We have an amazing guest who's going to give us both phases in excellent detail, and we're really excited to hear from him. Joining us today is Deputy Public Defender Tom. Tom, please introduce yourself to the members of the jury.
Good Friday to you, members of the jury listeners. My name is Tom.
Tom, we really appreciate you reaching out. You know, for me, I love this connection of being able to communicate and relate with public defenders from across the country. There's so many different forums and ways for us to connect, and I was able to meet Tom in one of these arenas, and I'm so excited to just see how life is in their shoes despite being elsewhere. So Tom, I want to get into the facts of the case. I know you gave me a little bit of insight, but aside from the nature of the charges, I don't know anything like the members of our jurors listening in. So why don't you take us to the case? What happened in this situation?
Okay, so this is a case that I got in 2017. The incident that it sprung from was in 2012, actually, if I'm recalling correctly. So basically, should I go into the facts of the case?
In a second, because I actually have a quick question about that. And so did that mean the initial filing didn't happen until 2017? And so there kind of essentially was a 5-year process of investigating before they filed charges?
There was a process of investigation that lasted a few days, and then a 5-year delay in filing charges.
Just because they wanted to sit on them?
I can elaborate on that.
Oh, okay, please. I'll stop interrupting. And yeah, take us to the case. Give us, first, ultimately, give us the breakdown of the complaint or information, and then kind of go into the factual basis as to how we got there. Okay.
My client was charged with 2 counts of attempted murder. He had a co-defendant who was his cousin. His cousin pled out pretty early on. So it was mostly just my client and I. The charges were 2 counts of attempted murder, to both counts, a firearm allegation, like personal use, discharge of a firearm causing great bodily injury. And there was a gang allegation, which increases the penalties pretty significantly. And those were the main charges. There are a couple of ones that aren't really worth addressing, but attempted murder, gang, gun. Like those are the big 3.
Exactly. And that's what we've talked about, that sometimes, there might be some other minor charges where you aren't necessarily going to trial to even factually dispute them, but they're so insignificant to the greater charges. And so even though they're throwaway offenses, it's for the principal cause. And so, let's keep it to the big stuff.
Yeah. So, give you a little bit of background. This incident takes place in 2012. No charges are filed until about 2017. So I don't meet the client until 2017. He's living his life. 2014, he did pick up some kind of shooting charge where he was represented by private counsel, and he pled to that and received a 14-year suspended state prison term. So he's placed on probation with 14 years hanging over his head. Like he, technically he could pick up driving on a suspended license, 14 years in prison. The case that I have, since it happened in 2012, actually would not trigger that suspended state prison, since the incident happened before he was placed on probation. Basically, my guy was alleged to have been a pretty known gangster in his town. The police were just gunning for him. So they pick him up on a BS dagger case. Like they see him driving a beat up van. They pull him over for some pretext, traffic violation, and they find a knife either in the van or on his person. I don't recall, but that was going to be the triggering case for the suspended state prison. And then I think, speculation, but just to add additional pressure to have him admit the probation violation and send him off to prison, they filed this case from the 2012 incident. So I meet my client in court for the first time. And the way it works in our jurisdiction is there are 2 court dates when it comes to the preliminary hearing. Do your listeners know what a preliminary hearing is?
Yeah, we've had a couple episodes where we've been able to explain that. But if there's the important part about the case, yeah.
So basically the way it works in my jurisdiction is someone gets arraigned. They generally do not waive time at the arraignment, so they're entitled to a prelim within 10 court days. So they will set 2 court dates after arraignment. Preliminary hearing confirmation, where you can show up and say either we're ready or we're not ready. And then a couple days later, the actual preliminary hearing. So I meet my client for the first time. I believe at that point, like, I was probably missing discovery. Obviously, it's a life exposure case. And I was like, we should probably waive time here. I want to, before we go to prelim, I want to have all the information, talk to you, that sort of thing. And he's just like, nope, not going to do it, not waiving time. He says, like, go talk to my mom. She's got some paperwork. Talk to the mom. She hands me this like thick stack of paperwork, and she's telling me all about how the cops are harassing him and everything. She tells me like this whole life story that I can't fully digest there. In court, I've got probably 10 other clients on for prelim. So he's one of many on that day. Anyway, I look at the paperwork. Here's where like the kind of palace intrigue comes in. Somehow, I got a hold of the internal district attorney charging decision on the 2012 case, where there's a big old stamp on it that says rejected. Okay.
Interesting.
So in 2012, after the incident investigated by the police, and it was a relatively short investigation, maybe a few days, a week at most, probably. The cops forward all that information to the DA's office. That's the regular course of business. Rejected. Sent back for further investigation. And I don't think that they did much further investigation. I think there was maybe processing of fingerprints or, like some other kind of nickel dime stuff, but they did pretty much 90% of their investigation, already. It was rejected for prosecution 4 or 5 times. And my client's mom provided me with that paperwork. So this is the only time that's ever happened. It seems that the
these letters getting mailed to them, or
it seems that my client got these documents essentially on accident. I think what it was, if memory serves, is that he asked his probation officer for just everything about his case, and they somehow that was in probation's possession, and they gave it to him. I've never seen that before or since.
yeah, that's so interesting because I know in my jurisdiction, so, like people can get notice of non-files, like after they've been arrested, and maybe they'll show up to their like initial court date on like a citation or something like that, and then on that day they can get a notice of non-file because to prove that they like came and like appear like they were supposed to, but there were no charges. But yeah, not to the extent where like they get the the notice of rejection. So that's just so interesting how they actually came a hold of them.
Yeah. So when you went through the documents, it got a little ambiguous as to whether it was rejected 4 times or 5. I think that there was a reasonable argument for either number, but also 3 or 4 different district attorneys reviewed that case and rejected it. So it wasn't just one DA who was saying this case isn't good enough to go to trial. It was a good 3 or 4 different individuals. So meter is, hitting red. Prosecutor who was now bringing the case, I think it was an in-chambers discussion, but I was definitely harping on this, and I filed motions to dismiss based on it. And this particular prosecutor who was bringing the case now, but she basically said that, well, she's an expert gang prosecutor, and she knows the law better than all these colleagues of hers, so she's going to bring the case. Ultimately, we go to trial. There were like 3 different motions to dismiss, all of them of course denied, so we go to trial. The factual circumstances of the case are essentially that there was a minor car accident. So there was the alleged victim's car behind my client's car. My client stopped at a stop sign, and the alleged victims like just sort of bumper kissed them, like minor little fender bender. I don't think there was any damage to either car.
Yeah, like a bumper tap.
Yeah. From my client's car, and there were 2 people at the time. They get out. The alleged victims from the car behind them, actually, at the time, it was one dude. This is one alleged victim at this time. He gets out of the car. I think he gets punched in the face. There's a scuffle. Words are exchanged. They ultimately, go their separate ways. Later in the day, the alleged victim went to a local convenience store, and the way he tells it is that he was just telling his friend about what happened, and then he happened to see my client's car drive down the road, and he says, "Oh, that's them. Let's go follow them." When you look at this friend that the alleged victim went and spoke with, when you see him in the courtroom, he's huge. How's the language policy on this podcast?
We're explicit.
Oh, great. Okay. He's fucking huge. He's fucking huge. Bro, no, you were not just telling your friend about what happened. You were getting muscle. You were getting some muscle backup. The 2, the one alleged victim and the soon to be second alleged victim, get in the car. They follow my guy's car around. At that point, there were three people in my client's car, two in the front, one in the back. Prior to that, it had just been the two of them. Victims lose my client's car. My client's car ends up behind them. So now they're being followed. They go out of this town into sort of the countryside, I guess you could call it, like sparsely populated. There's like a cemetery out there. And a shooting happens at this sort of remote intersection. And one of the guys, one of the alleged victims, I think he got his hand grazed by a bullet. That was the only injury in this whole thing. After the shooting, the two cars go their separate ways.
Let me ask: was there only like one shot fired, or were there allegations or evidence like of multiple shots fired?
Multiple shots were fired. Like multiple shell casings were discovered at the intersection.
Oh wow! Okay.
The alleged victim's car had multiple bullet holes. So yeah, so there was like a reasonable dispute that some sort of altercation, right? But it was not clear who did the shooting. There was contradictory testimony from the alleged victims as to whether it was the passenger or the new third guy who showed up in the backseat. Long story short, like the alleged victims, they pull over in a more populated area. They flag down a police officer. They tell them what had just happened, how an investigation is going. They eventually my guy to the car. This white Taurus was my client's car. It was his girlfriend's car anyway, and he was associated with the car in the police records. So ultimately, he's arrested and charged, and we go to trial.
It sounds like, and all of that investigation you said was initially done back in 2012, and that's when they were even able to attach him to the car back in 2012. Correct. Okay.
Yes. All this happens within a few days of the incident.
And so back in 2012, they have the car, quote unquote, at the scene of the crime. They have what they believe is evidence that he was driving the car, and at the scene there was, but if I heard you correctly, the contradiction between who the shooter was one of the two passengers, and if I'm understanding what you're saying, your client was the driver.
Yes.
Okay, great. So no, I think that I was able to digest all of that as well. So we go to openings. We had an opportunity to discuss a little bit before we started recording that there weren't really too many evidentiary issues. And, after hearing that, was there anything with regards to the timing, though? Or I guess did that play a factor with any of the potential evidence that they were seeking to admit? Like, did they still have the exact same two victims from all those years ago?
Shockingly, they did. I was, wow. I was surprised. One of them had left town for a bit, like a few years, but was back. And the other guy, I think, had never left. I think Muscles had never left.
I love that nickname.
So the original alleged victim, the guy who went and got Muscles, was legitimately his nickname was Cowboy, because he wore like very flamboyant imagine like it's a cross between like a cowboy and Liberace, like rhinestones, big old 10-gallon hat, but he was just like a field worker with just a very like eccentric sense of style. So we got the alleged victims, cowboy and Muscles.
Tom, let me ask you real quickly, because after you say that too, I'm actually kind of surprised that they went with attempted murder as opposed to, assault with a deadly weapon. Did you get that sense that there was some overcharging too, or?
Oh, definitely.
Okay.
It's in my jurisdiction. I mean, it's overcharging central.
I think that's a lot of jurisdictions.
Yeah. As far as like the trial goes, like of course I wanted to bifurcate the gang allegation away from the underlying facts. That was denied. And let's see. So I ended up going with conceding that my guy was a gang member. Like all this inflammatory gang stuff was going to come in. I tried to in limit out, but obviously, like, it comes in. So his like homemade rap videos, his prior contacts where he like admits to it.
I have to ask, especially in light of what's going on with like, Young Thug and the rappers in Georgia who, they're using the evidence of their songs against him. Were any of his like rap videos in some way lyrically connected to factually like the to the case?
No, not to the case, but they were about like the quote unquote gang lifestyle in general.
Right. Okay.
The one that sticks out in my head was called Putting in Work. And of course the gang expert that the district attorney ended up calling was, went into great detail about what putting in work means and how it's a requirement of the gang and stuff. And that one was actually a catchy tune.
Was it?
Yeah.
I love when they're actually not bad. Like, at least it like that part's enjoyable. Like, not only would it be sucky to have it be like shitty evidence, but then also to be like a shitty song. Like,
Yeah, that one I was like, I told my client too. I was like, hey man, I got that video. It's like, it's not bad.
That's awesome.
So I went in conceding that my client's a gang member. Like, look, you're gonna hear all this evidence. See him in the courtroom. He's got the 4 dots tattooed on his face. Like, we get it. He's a gang member. But going off, the defense was basically he might have been a gang member, but the actual evidence, like connecting him to this crime, was kind of weak. And even if you find that he did do it, it was not gang related. During that initial scuffle that that cowboy and the 2 people in the car got into, that initial bumper kiss, nobody was like a gang name, nobody was flashing gang signs or colors, nobody was dressed distinctively in a gang color. And same thing for the shooting incident. Like, nobody said it, nobody hollered a gang name, made signs, or anything like that.
Were the alleged victims known to be in any kind of gangs, or was that ever like a issue that came up?
The only that came up with Muscles a little bit, because Muscles like happened to be wearing blue, and my client's gang associates with red, but there was never any evidence to suggest that they thought that Muscles was a rival gang member. And take one look at Cowboy and you're like, man, I don't know any gang that dresses like that.
Okay, makes sense. All right, so then take us to the opening statements. What were some of the things that the prosecutor, tried to highlight to the members of the juries for their point of view, and then what was your goal and message to the members of the juries during your opening statement?
I think the DA's opening statement was honestly it was pretty bland, like just pretty vanilla. Um, to my recollection, she was just like, "You're going to hear this evidence. You're going to hear that evidence. You're gonna, and that's why at the end of the day, we're going to ask you to convict this guy of all the charges." And mine was highlighting what the weaknesses are going to be, or at least hinting at them, and like getting the jurors to be like, "Oh, well, what gunshot residue, like that's there's something weak going on there." Like um getting right out in front of the gang stuff, saying, "Hey, he's a gang member. No one is going to dispute that." I kind of felt like it would be, I would lose credibility, if I was to argue that my guy with, a bunch of pretty convincing gang tattoos all over his body and rap videos and stuff, that, and a record, that they're going to hear about, wasn't a gang member. So just get out in front of that.
That sounds like a really smart strategy, and one that I know we've encouraged on the show in the past, just because, you're going to have bad facts in a case. If you didn't, you wouldn't be having a case. And so I think you really hit the nail on the head with the maintaining your credibility with the jurors and just honing into it. Because at the end of the day, as it relates to the charges, you're right in that just because it's not unlawful, quote unquote, to be in a gang, it's when you commit crimes in the furtherance of it. And so just because he may be in a gang doesn't necessarily mean that everything that he does is for the purpose of advancing that lifestyle or his gang as a total. So I think that's really smart and an encourageable strategy to do an opening, and especially to then also plant the questions that you don't think can ever be answered by the prosecution throughout the trial. So that sounds like a really smart strategy.
Yeah, and I'm trying to remember if this happened in the prelim or in the trial, but at one point, maybe it happened in the first trial, but the gang expert cleaned it up in the second, in the retrial. But the gang expert was testifying for the listeners. The DA can put up a quote unquote gang expert as if they're like a scientist, as if they're like a physicist or something of that nature. And then they can just say basically whatever they want about gangs and how they work. It's really inflammatory and unfair, but they're allowed to do it. I think I got the gang member to say that, well, his position was every crime that a gang member commits is for the benefit of the gang. And I'm like, drunk in public, domestic violence.
Those are really good.
Some of those will actually get you killed by your fellow gang members. Like,
right.
Fuck off. I'm pretty sure he stepped in that trap in the first trial and cleaned it up in the second, where he was like, well, not everything, such as domestic violence or child molestation.
Yeah, and I think that's somewhat of a pattern that, in my opinion, law enforcement tend to have is really just try to oversell their position. And I understand that, police officers get a lot of slack and criticism, but like they're human. They're going to make mistakes. And I just, where you address the bad facts, I think that they have a hard time doing that, in my opinion, on the stand.
I would agree. I think that they try to spin everything in a positive way. And like if you have a couple of critical thinkers on the jury, you can really point that out and raise doubt that way. So basically, my primary argument was like, not my guy didn't do it, because he wasn't going to testify, and there wasn't really any great like self-defense argument to be made. So eyewitness identification was pretty weak. I mean, the police did a, photo lineup with my guy. And I think that they identified him, but not like 100%. They're like, 80% sure, or something to that effect. And, of course there was the discrepancy about like who did the shooting.
It just sounds like so many like unanswered questions that I'm interested to see, what their proposed answers were.
So there was, my client invoked, he was a pretty smart guy. So he invoked, and his co-defendant did too. So there were no issues with their statements coming in or anything. And we did get into some forensics, which was the first, I want to say it was the first time that I had to deal with that in any extensive way. And that was with gunshot residue. So I did do a gunshot residue swab of my client's hands when he was arrested. And he was arrested on this case, I want to say within 24 hours, maybe within 48 hours of the incident. Pretty quick. And what the Department of Justice analyst explained, which is true, was that they really liked the DOJ person. Like they weren't just totally in the bag for the DA, like they were a real scientist. And they said, hey, like, I'm not going to call this gunshot residue because gunshot residue is made up primarily of three elements: lead, barium, and antimony. So when we have those three present, we call it like probable gunshot residue or possible gunshot residue. But because all three of those elements exist in the world, like you could have them on your hand and have it not be gunshot residue. In my client's case, they found one particle on each hand that only contained two of the three elements. I can't remember which one was missing at this point, but like, let's say it was lead and barium and no antimony. So I made a lot of hay about that. And I would say that was kind of the majority of the evidence. They did call, the district attorney did call my client's fiance to the stand because she was the owner of the car. And she unfortunately spoke to the police when they were in the process of investigation. And she had told them, like, when they initially arrived to ask about where my client was and where the car was, she was like, well, I don't know. Like, we broke up 3 days ago, but then immediately contradicted that with like, oh, but I just saw him. And, it was not good. She did not do my client any favors.
Was she called in? Now, I heard you say there was 2 trials, and I'll kind of have you break that down for us here in a second, but was she called in both of the trials?
I believe she was.
Okay. And
I would say that the second, like the retrial, was pretty much a rehash of the first one. Like, for everything I'm telling you, yeah.
That was going to be my question was there any significance or substantive change in any type of evidence that they presented in the second trial?
It was the same.
Did you feel that your defense had been disadvantaged at all now, since you had already exposed it to them during the first trial?
Yeah, I would say so. And again, I didn't really have anything else to go with. It's I'm sure your audience knows, like, basically what it boils down to when it comes to a defense is either like, I didn't do it, or yeah, I did it, but some sort of legal excuse that, excuses your actions, such as self-defense. And I, just didn't really have a way to put that on. So yeah, so fiance testifies, definitely looks like she's covering for my client. That no way around it. It looked pretty sketchy and bad. And I really thought that so we get to closing argument, and
Well, let me interrupt you right before you get there, because I wanted to ask you real quickly though, what was some of the evidence that you felt was critical that you were able to get out throughout the trials that, ultimately played a role in, the just verdict that you believe this case ultimately concludes with? I know that you had briefly mentioned that the first trial ended with a hang and that the second one didn't go our way. But throughout those trials, what were some of the more critical pieces of evidence that you really made sure to elicit?
I would say it was just I didn't have one particular thing to hammer on. Like, I don't think that there was like a silver bullet, so to speak. So I took the strategy of doing like death by 1,000 cuts, right? Just point out the weakness in the identification, point out the weakness in the gunshot residue. I think that probably like the biggest ones, I mean, they didn't find any spent ammunition in the car. And obviously, like, my client didn't make a statement. So my strategy was basically, just to raise all these little bits of doubt and try and like pick off some jurors.
At either of the trials, did any of the victims then say your client was the one who ultimately shot them? I guess I never came back and connected that. Like, originally they had told the police it was one of the passengers, and then did that then change at trial where they did say it was your client? Or
No, they pretty well stuck to their initial statements about, like, well, like, one of them thought it was a passenger in the front, the other thought it was a passenger in the back. And yeah, they didn't really change anything substantially or substantively. There may have been a few details, but again, it was, 5 years later or something. So
that's so interesting. Okay, so we have this encounter in 2012 with, your client, his friends, and a victim who started the whole thing by bumper tapping your client and then following him after what I'm going to assume he got beat up after the bumper tap that he did. And and then we have these trials where there's a lot of questionable evidence. I think that's solidified by the hung jury that rendered in 2017. And then unfortunately during the retrial, that ended. What happened in that ultimate retrial? Was he then unfortunately convicted of all charges?
Yes. So first trial, I think that, and it pains me to say it, but I thought the DA had a very effective closing argument. Since my strategy was to just pick at every little thing, she did this thing where she, like, got a bunch of popsicle sticks and put them together and was like, showed like that, how to explain it, like nobody's that unlucky, kind of. One or two of these things can be explained away, but when you get to the weight of the evidence, even with the doubt that I thought I was able to raise, that I was able to raise in the first one, that no one could really be that unlucky. And I was to the retrial. It hung 10-2, by the way. It picked off two people. To the retrial, I was like, I don't really know what I'm gonna say about that, like, in my closing. But she ended up not going with it. She didn't do the same thing, which I honestly thought was pretty effective. And great, fine. But unfortunately, they convicted that time around. I should say, in between the two trials. So Trial hangs. Go back to negotiations about potential settlement. And the second time around, the DA was willing to offer 20 years, package deal for everything.
So that would have included the 14 years that was previously stayed over his head.
So like, so I told, I was like, hey, that's not bad. Like it hung 10-2, made them work for it. You got 14 years hanging over your head anyway, which you're going to get because of the BS, like Dirk Dagger case. Like, you're a young man. It's 6 additional years. Don't get me wrong. I would not want to do 6 additional years in prison, but reading the tea leaves here might be a pretty good resolution for you. And he said no, so we went to trial again.
Were they still adamant about him being convicted for attempted murder?
I think that they were. I can't recall if I think we must have come to a different charge because you can't get just 6 years. So I think that their main concern was they didn't want my guy on the street. It was a kind of a small town. They felt that my guy was like a bad dude and a troublemaker, and they just wanted him off the streets for a decade or two. And I was like, if a client had come in with this case or something similar, and the DA was like going to offer 6 years on it, I'd tell my client, I'm like, hey man, like either there's something really, really wrong with their case, or it's an amazing offer that you need to grab and run with it. But yeah, he didn't want to do that. So we do the retrial, and the second trial goes basically the same, evidence-wise. The jury convicted. I had to go out in the hall, tell his fiance and his mom like what had just happened and how, he was looking at, many, many decades to life, and realistically was probably not, going to get out of prison. And man, his fiance like let out this wail, this like animal scream that like haunts me. It was the worst thing I've ever heard in my life. Like the pain that she was in. I learned that they actually locked down the courthouse when she screamed, because they thought, like the bailiffs thought, maybe there was some sort of, horrible crime occurring in the hallways, but they locked all the courtrooms down. Someone called 911 and got, because we thought maybe she was having a panic attack or something. And so an ambulance came with a couple of paramedics, and I really wish I had like one of their contact information or something, because they did an amazing job of like calming her down. Like, it just blew me away. I was very impressed by the paramedics and how they figured out what was going on. Like I kind of explained the situation to them, and they gave her a pep talk about, like how she's got to be strong for her kids and all this kind of stuff. And, just kind of brought her back to us, which was nice.
That's always a part of trials that a lot of people don't really conceptualize is that it's not just the person on trial who's affected, that everybody who's charged with crimes is, brother, sister, mother, father, somebody to somebody. And a lot of times, even in my opinion, even if the person did commit a crime, it's not easy for their loved ones, and they those feelings need to be addressed. And oftentimes, especially as public defenders, we bear that burden. And I think we're happy to, and we know it's part of the job. So I think that does sound like a great situation to how that ends. Because unfortunately, as I'm sure people are aware, like, it doesn't always go that way when people have emotional outbursts to negative results in court, especially when the people having the outbursts are people of color. It's more so seen as aspects of aggression or retaliation instead of a true just emotional like tsunami that just happened. So that's a really interesting detail and one that I don't think we've actually covered before. So I appreciate you bringing that perspective.
I will say, just as like a general matter, when a client is getting sentenced, we get the probation recommendation, and probation will go through, and they're ostensibly this objective third party who's not like, vested with the prosecution or the defense or whatever. But like, we all know they're cops, and we occasionally get these reports which follow our clients to prison and have an impact on their living conditions in prison. And they'll say like, oh, well, this guy's been to prison before, so only going to have a moderate impact on him and his, 5-year-old child or whatever. Again, I'm just speaking in generalities here. And I object every single time. Like, going to prison is a major impact on anybody and anybody that they're related to, full stop. And it disgusts me when I see the probation department try and say like, it's fine,
It's a couple extra months or days or years. I think you're absolutely right. There's so many people who, get really desensitized to that aspect of it, especially when your job is to sit on a calendar and literally recommend prison sentences for, 5, 10, 20 people day in and day out. Like, it becomes really easy to say, well, there's really not a big significance between a recommendation of 4 years or 6 years or 8 years. It's all relatively close in time, and every day matters to these people. So, Tom, I want to get into it as we start to kind of wrap up into the show. Obviously this has been a unique episode, and I'm really glad that you've been able to bring us this type of perspectives with the huge charges of attempted murders. We've never had discussions about, 2 trials. And at the end of the second trial, we didn't get the just results. I'm curious, when we had the opportunity to for you to do a trial breakdown, what was the significance of bringing this case to our box to, highlight what was the just result that you really wanted you to share this story?
So the case just came back on appeal, which, client gets convicted, I file my notice of appeal. And for me, like, my job is basically done. Like, my client will get appointed appellate counsel. Well, not only has the gang law changed, like in California, are you based in California?
Yes.
So and AB Assembly Bill 333 changed some of the gang laws, and the appellate court, they not only said that the conviction in this trial, now the sentence is not final because it's still on appeal, and when someone's sentence is not final because it's still on appeal, they can take advantage of changes in the law that benefit them. They can go back to the trial court for resentencing. But in this case, the appellate court said, not only does the evidence in this case meet the new gang standards, which normally, like, the flip side of that coin is that the district attorney would get a chance to introduce new gang evidence to keep that gang conviction in place. They said didn't meet the old standard where like basically a cop could just show up and be like, yeah, he's a gang member, and like that was it. The court pointed out this is why it's important to make a very good record when you're in trial. Like no gang colors, no one shouted a gang name. Like the district attorney's argument was that, well, shooting what benefits the gang by benefiting the reputation of the gang, and it benefits the gang member by giving them status within the gang. And the appellate court came back and said, it does not benefit the gang when nobody knows gang is involved in this crime. Who am I going to be afraid of? They don't shout, whatever the gang member name is, or display colors or gang signs. There's no reputational benefit, which is one of the things that the law changed. It didn't commonly benefit the gang, and essentially just wasn't shown to be a gang-related crime. It was like more of a road rage incident. So the appellate court is sending it back saying, not only did you fall on your face with the new higher gang standards, but you didn't even meet the lower ones, which really made me feel good. In my mind, the DA gets to eat their words about, oh, well, I'm the experienced gang prosecutor. I know better than the 3 to 4 other members of my office who rejected this case before me. He's like, well, maybe they knew things a little better than you did. So it's coming back. Gang stuff be dismissed because the firearm allegation based on it being a gang case that falls away too. A good 40-ish years or something, or like off of the final judgment. And I have to sit down and do the math, and of course the resentencing hasn't happened yet.
Well, and I'm wondering, does he not potentially have a claim for a whole new trial then? Or I guess that they didn't necessarily say that the gang stuff that came in was inadmissible. It just wasn't enough to meet the threshhold.
Correct.
So his gang ties would always come in to the trial, because I was wondering, because I would think that would have a huge impact on a retrial again on a third case if they weren't able to then also say like the whole time he's a gang member, because obviously that's going to inflame the passion of a jury.
I think that you are correct that it would definitely make the trial go a different way, but that's not going to be an option for him. They didn't disturb the underlying attempt murder. I should say that the jury did not convict him of the firearm allegation where it's where it results in great bodily injury, which is the highest triad for that, because the graze of the hand is just not GBI. So anyway, a good 40-ish years are coming off the sentence here whenever he comes back to court in a few weeks.
Well, Tom, I think that's not a small milestone. Like we just talked about, every day, second, hour that someone is unfortunately sent to prison is just not necessarily too long if there's convictions, but there's impacts that go around. And our jobs as public defenders, I think in our community, we understand the significance of small wins, especially when the deck is always stacked against us. Not everything has to be a home run. There are victories in that. And, like you indicated, he's a younger guy. And so the 40 years coming off allows him to, what I would assume, potentially see the light of day again.
I think he will. I think he'll at least have that possibility, which is huge.
And that's huge. So that's no small victory. And, obviously we love to hear acquittals in in this podcast, but it also goes to shows that our jobs are so much more, and we really highlight even the little victories. And that's what this case was. And it was really impactful. And I'm really glad that you came and gave us your time. In general, what would you say is the significance of taking matters to the box to speak up against adversity?
It's so important on a number of levels. By the time you get to trial, your client has been slandered by the DA at a bail hearing, held to answer at a preliminary hearing. Like, it's finally their time to speak. And so it's significant for them to be able to get up and say, no. Like, now it's my turn. Like, you've arrested me, you've charged me, you've painted me as this horrible person. You've probably blasted my face out on like social media saying like, oh, look at this awful person who got arrested for thus and so. And no, like now it's my turn. Now I get to say my side of the story. And it's really significant. That's one of my like favorite things about going to trial is like just finally being able to fight back. Don't get me wrong, you have pretrial motions and stuff, but like when it comes down to it, the trial, it's for us. Like, it's for the defense, it's for the defendant. And it's really funny to hear, sometimes you hear lay people say like, like there aren't enough trials, there are like too many plea deals. And it's like, man, you got it backwards. Like, the DA wants a plea deal. Like, that's easy for them. Like, they hardly ever have to work for a conviction. And to make them work for it, to like hold their feet to the fire that way. And very oftentimes with the overcharging that they do in my jurisdiction, like my office wins way more than
same here.
We have any reasonable right to. Like,
I loved all of that. I really did. It may be cliche to say, but we are the voice of the voiceless. Especially as public defenders and the vast majority of our clients who fall into, the poor, the minorities, the mentally ill, the most vulnerable people of our community. So I really love that passion, and I felt that throughout this episode. And I just can't thank you enough again, Tom, for giving us the time and sharing the story. And thanks so much for coming on the show. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. Information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.